Hello, Con Law class. Welcome to the review for week 6. And this was an interesting week, this past week. We covered a lot of material. It's kind of difficult to summarize it in any kind of sort of concise package as we talked about during the week. We spent most of the week talking about executive detention and the trial of enemy combatants and the really difficult and interesting constitutional history arising out of 9/11. There are a few rules that we can pull out of these cases, but I do think it's important that you have a feel for the different perspectives and opinions and jurisprudential approaches in the cases, because the kind of question that you're likely to get, whether it's potentially on an exam or on a bar exam or out there in the world, is not likely to be a specific question unless you're working on these particular Guantanamo cases that's addressed by these cases, but it's likely to be something in which you'll need to take some of these arguments and kind of extend them and apply them and sort of figure what different approaches would be on different sides. So we went all the way back to the Civil War. We talked about Ex parte Milligan. We talked before that about Lincoln's suspension of habeas corpus during the Civil War. And then we talked about Milligan and the effort to have this civilian in Indiana tried in a military tribunal, and the court saying that that was not proper, that a civilian in a state that was not actively in rebellion is entitled to a criminal trial, whether it's a charge of treason or whatever it might be. We then talked about a couple of cases from the World War II era. We talked about Quirin, and we talked about kind of the background of that case and these Nazi spies who were coming ashore in the U.S. And in that case, there was a distinction made between armed combatants and unlawful combatants, and it was found in that case that these weren't armed combatants on the field of battle, but they were civilians acting as unlawful combatants, which meant that they were not entitled to civilian process and that they could be tried in a military tribunal. We then also talked about the Einsteiger case, and there we had people that were captured on the field in a foreign country, and the question about whether those people were entitled to habeas corpus, and the court saying in that case that those people in a foreign country, captured and held in a foreign country, are not entitled to habeas corpus. So then we kind of looked at how all of that might apply in the War on Terror. We talked about the authorization for the use of military force and how that plays into these questions about the War on Terror. We talked about the Rasul case, and there the Supreme Court saying that in fact the habeas statute does apply to the territory of Guantanamo Bay, even though it's not a U.S. territory. It was considered by the court to be an area over which the United States effectively has sovereignty, even if not ultimate sovereignty. We noted that Justice Stevens distinguished Einsteiger and kind of viewed Einsteiger as sort of almost providing some factors to look at in determining whether a particular alleged enemy combatant is entitled to habeas or not. Stevens said, there were many markers in Einsteiger that said these are people in a different status than the people who are being held at Guantanamo. We looked at the Hamdi case, and here we have a case that's involving a U.S. citizen, and then the question is, well, what kind of status are we going to give to a U.S. citizen who's seeking habeas relief? And we also had the beginnings of kind of the legislative development of Congress going back and forth, in a sense, with the court and trying to address the status of these detainees. And Justice O'Connor here saying that we didn't need to reach the separation of powers issue because the AUMF gave the authority to detain him, but that and that military process is appropriate under Quirin, but that it can't be indefinite, and further that there's a certain kind of process that is due. And O'Connor says using an intermediate scrutiny test borrowed from the due process jurisdiction says that we have to kind of balance this out, and that at least in this case the citizen who is being held has a right to be heard on whether or not, in fact, they were an unlawful combatant before some kind of neutral decision maker. O'Connor says the proceedings can be tailored. They don't necessarily have to have all the guarantees of a normal criminal case in federal court, or even necessarily all the guarantees of other kinds of military process, but kind of leaves that open. And further, O'Connor says, this doesn't apply to the initial capture on the battlefield. The initial capture on the battlefield is, a matter of exigency on the battlefield. You don't have to go through all this process at that moment, but once you've captured the person, it's not really, in that direct sense, a war powers issue, but then it moves into, effectively, she's saying, a due process issue. We noted the beginnings or the kind of continuation of some of the doctrinal and ideological disagreement here. And here we have Scalia saying, and this was a bit surprising to us as we talked about it in class, but here's Scalia taking a strong position on the suspension clause as applied to citizens. And Scalia is saying that the suspension clause means that habeas cannot be suspended for U.S. citizens. The law of war cannot be applied to U.S. citizens where the courts are still open. Further, Scalia kind of plays with these separation of powers questions and says that it's clear to Scalia in the structure and text of the Constitution that Congress declares war, the President commands the military forces, but the President's authority really is limited to the command of the military forces, and he wants to maintain this careful distinction between civilians and the process that's due civilians and the military and what happens on the battlefield. Notice that Scalia also says that the requirement might be different, although he doesn't specify why or how, if the citizen is captured and held outside of the United States. We noted also a difference with Justice Thomas, where Justice Thomas said the President has an inherent war power and power under the AUMF to use these kind of military procedures, and that due process in this kind of context only requires a good faith determination by the executive that in fact this is an enemy combatant or an unlawful combatant. We then looked at the Hamdan case, and Hamdan, you remember, was Osama bin Laden's personal driver, and we have here kind of a longer history of a statutory background. Remember that part of the issue that wasn't so fully brought out in our casebook with Hamdan was the question of the charge against Hamdan, which was really a conspiracy charge. It wasn't an allegation that he was sort of a leader in Al-Qaeda or was himself actively involved in plotting terror attacks, but that as OBL's driver, that he therefore was in some way a conspirator. And so Stevens, first of all, says that conspiracy charge is not the kind of charge that can be brought. And then in the portion that's really talked about more in depth in our casebook, he says the procedures are inadequate. They don't satisfy the Geneva Conventions, which he holds do apply as rights that these detainees can assert. And there's a number of reasons why he says the procedures don't work. And then he further says under the Uniform Code of Military Justice, which he believes is the appropriate statute to look to in terms of the scope of executive authority here, that the procedures are not adequate and don't really satisfy even the procedures that are ordinarily offered to persons that are being charged and held under the UCMJ. We noted this concurrence by Kennedy and just kind of noting that this is, in Kennedy's view, and those who joined with Kennedy in this concurrence, this is a separation of powers issue of the highest order. The Youngstown framework should be applied, and the UCMJ is the proper statute to look at, creating a conflict with the procedures the executive wanted to use. Exactly on the opposite front, we saw Thomas here now joined with Scalia and Alito and saying, yes, Youngstown is right, but the AUMF authorizes this, and that in fact the AUMF is broader and more recent than the UCMJ and is the proper standard to look to. Further, that the majority is really misreading the Uniform Code of Military Justice, which, in the view of the dissenters, gives the executive a broad range of discretion when it's not practical to use some or all of the procedures in that statute. So we then looked at Congress's response to the Hamdan case, which was to pass a specific statute dealing with the ability to hold military commissions, to try these prisoners held at Guantanamo, these alleged unlawful combatants, through military commissions, and stating that habeas corpus would not be available to these detainees. And we saw that case get up to the court in Boumediene, and there we saw Kennedy invoke the suspension clause and say that the suspension clause is a piece of the constitutional structure that provides rights to these detainees that Congress effectively cannot, in the way that it's trying to do here, suspend habeas corpus consistent with the Constitution, and stressing the importance of the writ of habeas corpus, trying to figure out how far the writ extends, noting that historically it's difficult to figure out where it extends, and then applying what he takes to be factors from Einstrager about where or when the writ should extend. And so we have kind of then some discussion from Kennedy talking about, well, do these particular procedures provide an adequate alternative to habeas? And he says they don't. There's really no effective judicial review, particularly in one of the key places where habeas could ordinarily be used, which is where there's some allegedly exculpatory evidence that comes to light after the conviction. And we saw the dissenters then say, no, actually, the statutory framework that's been established is Congress speaking. It provides these foreign combatants more process than foreign combatants are even ordinarily provided in the nation's history, and that all of that is more than adequate. We also then saw Scalia saying very specifically the writ of habeas corpus does not run in favor of aliens abroad. So we see in Scalia's thought this distinction between, particularly important to him, the distinction of citizenship or aliens, and then also some discussion about kind of the location of where the events happen and where the person is captured and held. So we talked a bit in class about, how does all this play out? And the fact that when we looked at the Youngstown framework and we look at the interaction of the executive and the legislative branch, and the fact that the executive branch acted and Congress several times responded in ways that seemed to confirm and endorse and reinforce the executive's action, and the court each time still striking it down. And we had a good discussion about what is the role of the judiciary in a context like this, a discussion that obviously we can't come up with a simple single answer to because there isn't one, but this is the broad kind of contour of the difficult policy debates and difficult legal and jurisprudential debates in a circumstance like this one. All right, we moved on then and we started to talk about bicameralism, presentment, and the legislative veto. We noted that this relates to the question of what are the legislative powers in Article 1, Section 1, and what is the meaning of the bicameralism and presentment provisions in Article 1, Section 1, as well as in Article 1, Section 7. We noted, first of all, that these provisions have never been interpreted to kind of literally mean that Congress can't delegate any of its authority to the president. And in fact, there's a pretty broad principle, the intelligible principle rule, which says that so long as there's an intelligible principle in what Congress attempts to delegate to the president, through which it can be determined what is or what isn't given to the president, that in general that's going to satisfy what's called the non-delegation doctrine. So the non-delegation doctrine itself seems relatively toothless. But then we looked at the question of the legislative veto. We looked at INS v. Chadha, and if you remember there, that was a statute involving the ability of the executive to suspend the deportation of certain deportable aliens based on criteria in the statute. This particular person, the executive had decided to suspend. The statute gave either house the ability to effectively override the president's decision to suspend that deportation. And Justice Burger said that doesn't work. That gives, it violates bicameralism because it gives one house the ability effectively to legislate. And it also violates presentment because this is one house making this decision and not going back up to the executive to look at it. So we talked a bit about how that fares in terms of whether it's actually a legislative act or just a resolution or some hortatory kind of action. So that's one of the things you have to figure out if you have an issue like this. Is it a legislative thing, or is it something more like just a resolution that isn't really a legislative act? We looked at Justice White's dissent, and then we had some good discussion in class about the nature of legislative veto, whether this is a good thing or a bad thing, how this relates to the regulatory state, and how these questions ultimately fold into questions about kind of bigger questions about the regulatory state, and even questions of administrative law. All right, so we covered a lot of material. Maybe we didn't cover as much ground in terms of kind of giving us rules and hooks to hang our hat on, but there's a lot to discuss, and you will want to know the contours of these debates as we move forward. Now, as we move into this week, we've got some really meaty stuff that we're doing. Tomorrow we're going to finish up our discussion of the executive with some very interesting material about executive privilege, about independent counsel, about special counsel, all of which remains very much in the news today and very much live. And then we begin to move into our discussion of the Bill of Rights and the incorporation of the Bill of Rights into the 14th Amendment and its application to the states. There's some historical kind of case law that's developmental, that's very important for us to consider, that we begin to dive into on Thursday. We continue to dive into that on Friday, and then we also begin to talk about the right to bear arms. Obviously, we've all been following the news. We know there's some really terrible things that have happened in Las Vegas, and we obviously don't want to exploit that circumstance, but it does provide just another example of the discussion that we need to have over these questions and the ways in which we think about these different rights and how they apply, what kind of restrictions are possible, whether restrictions are even meaningful in circumstances like this. All of these are things that will be, I think, good for us to talk about in class. So I look forward to this week, and I will see you in class tomorrow.